Most people who come up with a new idea think that they need to get a patent to protect their invention right away. Is this really the case?
Well, we see it all the time, and it's understandable that people would want to protect their idea so somebody else doesn't take it.
And while patents really do have their place, there's a lot of steps that need to happen before they spend money on a patent.
But there's so many things that people don't know about patents.
What kind of things might surprise people about a patent that you share in the Inventors Action Program?
Well, even if you have a patent, that doesn't guarantee that somebody won't take your idea and sell it.
And it's the responsibility of the patent holder to find those who are infringing on their patent and then take legal action at their own expense to try to get them to stop.
And defending a patent can be really costly. Actually, often is the case that it's going to cost more than it was to get the patent itself.
Mm-hmm. You have to get a patent in each country that you want a patent in. There isn't like a worldwide patent.
And then there's this thing called full disclosure that we were very surprised to find out about. And that is within 18 months of filing for a patent, whether it's granted or not, all your information is made public for everyone to see.
Well, these are certainly things people would want to consider before applying for a patent.
Absolutely.
I think it would be best for inventors to speak with a lawyer then.
Yes, they certainly should, but they should also get a hold of our program first because there's a lot that they can learn about patents and protecting their idea before they meet with a lawyer. The lawyer we actually had worked with and spoken with had said the first hour she spends with a client is often used just answering very generic questions.
And after working with our program, they'd be better able to ask specific questions without wasting that time. And at $400 to $500 an hour, you really want to ask the proper questions.
Are there any basic steps inventors can take to protect their idea in the early stages?
Yeah, actually, NDA, a non-disclosure agreement. We actually had a lawyer at a leading firm in the city write us a generic NDA agreement. And within our program, we show inventors how to better strengthen that NDA.
Can't you just download an NDA off the internet?
Yeah, well, sure you could. You could have an agreement on a napkin as well, but obviously the stronger the agreement, the stronger your protection is. So with an NDA agreement, you have to ensure that it's written and filled out properly.
Does this program have value for those who might have already started the patenting process?
Yes, a patent is just one step of the process. Just because you have a patent doesn't mean your idea is going to succeed. There's still a lot of work to be done. And if you've made that commitment with a patent, you really have to get moving now because you've started a timer on yourself.
And everything is still relevant in the program, including the section on patents and legally protecting your idea. A patent doesn't come with a handbook. What we've even found is a lot of inventors have come to us with their patent in hand and asked us the question, what now? Like, what's my next step? And now we do have a good answer for them. It's the Inventors Action Program.